him to lunch. And hope that it in some way rubs off.
That's a good omen for my presentation, actually.
Oh, yeah, and the other guy that we have here today is Josh Blackman, and since I was only here for part of the speech and missed the hiring meeting entirely, it was thought appropriate that I should introduce him. Josh is an undergraduate from Penn State, where he did not play football, and got his JD from George Mason, both of them with honors. He's clerked the federal district and circuit level, and despite the fact that he's just starting out in academia, he has already published or had accepted for publication a totally ridiculous number of articles, which doesn't bother me, but should have people like Drew and Jeff Korn really looking over their shoulder. He also does some things I don't quite understand. There's something called a blog, and he was on the top 100 of whatever those were for law, and he does stuff with the SSRN, which I believe is a Russian anti-missile system. And he's also working on a book, which, I thought we had delegated that exclusively to Mark Steiner. In any event, he's going to talk about the ACA, which I didn't recognize initially, but it's easily understandable. It's now called Obamacare. And basically the movement that led to Obamacare coming about, and one of the cool things is it can be traced, the idea of taking previously untested, unimagined constitutional concept and almost pulling out a win from the U.S. Supreme Court on something that no one thought stood a chance of snowball in a warm place of succeeding. And he was there at the original meeting where the original idea came up, the Federalist Society of Lawyers meeting. And so he's kind of in a pretty good position to talk about it, so I'll let him.
Thank you so much for that that warm introduction. To our friend from Georgia, welcome. First of all, thank you everyone. The last time I was at this podium, I was on an interview. I was very nervous. I had no idea where I would be the following year, and I was out of my mind. And now I'm here. I'm at South Texas. I'm very happy. We are 1/4 of the way through the semester, and I've had no students demand my firing yet, so I think I'm doing okay so far. And everyone's been very warm and welcoming, and I want to thank you all. So we all know about the healthcare case. We all heard about it in the news. We've heard about it nonstop for the last 2 years. You know, the president passed this big healthcare law, went all the way to the Supreme Court, and it almost got killed. There's rumors of the Chief Justice switching his vote. We don't know if those are accurate or not. But this is a huge case, which affected a lot of people. But let's take a little bit of a step back. Let's go back to, say, fall of 2009. We have a couple of common law professors here, but I'm sure people who just know this stuff about anecdotally will answer this question well. If I said Congress wanted to pass a statute that imposed a penalty on people who didn't purchase health care, and the reason why this penalty would be imposed is because there's a huge overrun of healthcare costs. People not buying health insurance would be shifting costs to others, and this is a way to make sure that everyone has insurance. This is kind of an alternative to kind of a single-payer system that they have in Canada. It's more of a free market-based system. If in November of 2009 I had asked any of you or any of the students, is this unconstitutional? The answer would have been no. Of course it's not unconstitutional. If any of your students had written that on an exam before 2009, you would give them a very bad grade saying you weren't paying attention in class. There's Wickard v. Filburn, which is a case about the wheat, saying that even if you don't move wheat off your farm, Congress can regulate it. There's Gonzalez v. Raich. This is a medicinal marijuana case, which says even if someone grows marijuana, keeps it on her farm, and there's no market for it to be sold, it's still interstate commerce, and Congress can regulate it. So we're talking about health care, something you actually have to buy. Something that obviously is crossing state lines because money is flowing back and forth. Something that affects millions of people, which is a huge market for it. How in the world can this violate Congress's enumerated powers? Fast forward to March of 2012, just a few months ago, when the Supreme Court heard arguments in this case. The justices were very much inclined to perhaps strike this down. Both Chief Justice Kennedy and Chief Justice Roberts were making comments saying this can't be right, this is unprecedented. You know, this is something which we've never done before. They came to the brink of striking it down, and ultimately the Chief Justice had this kind of funky vote I'll talk about in a few minutes. How did this happen? How did constitutional law change? How did the way we look at the Constitution change in really less than 2.5 years? And that's the story of what I'm going to tell you today. I'm working on an article, the title is Unprecedented, and this is actually a phrase that Randy Barnett, the so-called godfather of this movement, kind of coined. The thought was that this kind of law is unprecedented. There's no Supreme Court precedent that affects this law. There's nothing that controls it. It's unprecedented. It's new. It's novel. In addition to the article, I'm working on a book by the same title. It hopefully should be coming out by fall 2013, if everything goes according to plan. And it really just tells this story. This really considers something called popular constitutionalism. The Constitution did not change between 2009 and 2012. The U.S. reports did not change between 2009 and 2012. The only thing that changed is how people viewed the Constitution, how the people actually understood what the Constitution means. This is kind of what this is how social movements evolve and change our constitutional understandings. In other words, to quote Jack Balkin, it's taking an idea that's off the wall, this crazy idea that a healthcare mandate is unconstitutional, and putting it on the wall, saying, yeah, Congress can't make us do stuff. Congress can't regulate inactivity. And this article tells that story. So let's just do a little bit of history about what the individual mandate is. The Affordable Care Act, this massive piece of legislation, requires that every person buy health insurance. This is to make sure that everyone has health insurance. It's an alternate to single payer. But there's one catch. What happens if everyone's required to buy health insurance, but someone doesn't? Say a person who's young and healthy, like me, waits to buy health insurance until they're sick. If the Affordable Care Act does not allow the health insurance companies to discriminate against me, say with a pre-existing condition or something of that nature, I can wait till I'm sick and literally buy insurance to the ambulance right to the hospital. If an insurance company is required to sell you a policy at any time, why would I waste money with a premium if I can just buy it right before? That's a very big problem. So in order to remedy that problem, there's something called a mandate. If you don't buy insurance, you have to pay a penalty or a fee or a tax. How you characterize it is somewhat up for debate. You have to pay something if you choose not to buy health insurance. This makes sure that some young pup like me doesn't, try and, mess with the system and wait till the very end when I need health insurance. Because if everyone did that, the market would just collapse. The health people call this a death spiral. If people start, waiting to buy health insurance at the last minute, the entire thing would collapse. This idea isn't new. In fact, it's actually quite old. It's about maybe 20 years old. In the early 1990s, when President Clinton and Hillary Clinton were trying to impose some sort of healthcare reform, which would have been close to single payer like they have in Canada, one of the proposals from conservatives at the Heritage Foundation was an individual mandate. This is actually a conservative idea. It's a free market approach. It's saying, hey, if you don't want to buy health insurance, you don't have to. But if you don't want to, we're going to fine you. And that's kind of a nudge to make you do the right thing. So this was a very kind of conservative free market idea. And this idea kind of lay dormant for many years until the 2008 election, in which case then Senator and presidential candidate Hillary Clinton was actually proposing an individual mandate. Kind of bizarrely, candidate Barack Obama did not want a mandate. His plan was actually very similar to what Romney's proposing now, which is even more funny because when Romney was governor, he imposed an individual mandate in his state. So everyone's just all over the place. The only person who's so when Hillary tried in the early 90s, she didn't want a mandate, but in the late 90s she did. When Obama was running for office, he didn't want a mandate. When he was elected, he did want a mandate. And when Romney was governor, he had a mandate, but now he doesn't want a mandate. You got all that? In other words, it makes no sense. But that doesn't matter. Because when Obama was elected, I think they took a poll right after his inauguration, and the second priority of what people wanted him to do, I think after the economy, was fix healthcare. That was his mandate. And he dedicated most of his first year in office to trying to enact this massive piece of legislation. And they went through many iterations with healthcare exchanges and markets and whether there would be a government option. You probably remember all these. But the most important part that really no one cared about to the very end was the mandate. No one objected to it. During the entire Senate ratification debate when this was being debated in Congress, no one had any objections to the constitutionality of the mandate. No one thought that, hey, if we require people to buy health insurance, it will be unconstitutional. Not until really almost the very end on Christmas Eve, I think it was actually December 22nd, there were some floor points, and a couple of senators, I think Cornyn might have been one of them, made a constitutional point of order saying, hey, this is unconstitutional. and it went nowhere fast. You might remember Nancy Pelosi famously responding to a question, is this constitutional? She said, are you kidding me? Are you serious? So what happened? This is that story. First let me do a timeline, then I'll go back to what happened before. So really this story picks up in December of 2009. If you remember, in the summer of 2009, Senator Ted Kennedy had passed away. Ted Kennedy was the 60th vote. In other words, the Democrats had enough votes in the Senate that they could filibuster, that they could block any filibuster. They had enough votes. When Senator Kennedy died, they lost that filibuster majority. A guy named Scott Brown in Massachusetts surprisingly won the election. He was the 41st vote. And at that point, the Democrats no longer filibuster. The reason why that's important is that when they had this supermajority, they weren't very careful how they were enacting laws. In fact, the House and the Senate before Kennedy's death had passed a version of this law. It wasn't the final version, but it had enough votes. And now, Harry Reid was put in this uncomfortable situation where he had to pass a bill that was kind of a draft version, even though that wasn't the final version, because it had a number of votes. Had he tried going with a new bill, he would have gotten filibustered and knocked out. So what the Senate actually had to do was pass an older version, kind of reconcile it with the House. And I'm not going into the procedural mechanism, but it's a very complicated procedure, and there was demon pass and other things of how to get this law through. But the manner in which it was enacted was very, very circuitous. In any event, on Christmas Eve in 2009, Congress passed the Affordable Care Act. At the time, I think there were maybe 2 or 3 objections made to its constitutionality. No one raised anything in the Senate other than these 2 point of orders. Everyone assumed that this might be a terrible policy, but it's perfectly constitutional. You know, the president had an election, mandate, hope and change, he won, fine. Shortly thereafter, though, steam started picking up. About 3 months later, the act was passed in the House of Representatives. The very next day, the president signs it into law. Leading up to this time, though, between really December and March, a number of lawyers started thinking, hey, maybe we can challenge the constitutionality of this law. There were 2 major suits that came about by the states. One was led by Virginia, in which Virginia filed alone. Another was led by Florida, where the Attorney General of Florida, Bill McCollum, and about 12 or 13 other states to start pulled together and said that this law is unconstitutional. Before the president's ink had even dried, I think he used about 23 different pens. You ever see when they sign the signature with a lot of different pens? It's actually kind of cool. So before the ink was even dry on the pen, you had complaints filed in Florida, Virginia, about 5 other places. I actually talked to someone from the Florida's AG's office, and they were literally an electronic filing system waiting for the thing to be signed and hit submit. And then they had some filing problem, they couldn't file it right away, they were going crazy. But I think that Florida beat Virginia by about 12 minutes. So it was a race. And the reason why it was a race was because they wanted to be the first at the Supreme Court. Everyone at this time knew that this was going to the Supreme Court. They wanted to be first. Virginia is interesting. It's something of a rocket docket, the Eastern District of Virginia. So it goes through very quickly. So the president signed the law. Complaints were filed immediately. And at this time, really, no one thought that this was going anywhere. Everyone thought this is a laughing matter. That this is some silly argument that a bunch of, right-wing lawyers have made up and, whatever. It's not going to win. That was until August of 2010, when a judge actually denied the government's motion to dismiss. This was the first recognition that this argument has some force. That this is not something that, Rush Limbaugh might be talking about, but this is something actually federal judges are accepting. Whether you agree with it or not, it's a different story, but it's actually enough that a judge could write an opinion, with a straight face. The next one came from Virginia, where the district judge actually granted summary judgment in favor of the challengers. He said that this law is unconstitutional. The judge in Virginia said that the mandate's unconstitutional, but the rest of the act stands. When this happens, people were going crazy, because this was actually recognition that an act of Congress had just been struck down. But even more significant was the one in Florida. The judge in Florida, Judge Roger Vinson, not only struck down the mandate, he said the entire Affordable Care Act is unconstitutional, the entire thing. And there was some serious wranglings over whether his opinion was going to affect immediately, whether it would be stayed, whether it would go into effect right away. Vincent's opinion is very noteworthy because he made references to the Boston Tea Party and taxation by representation, and he quipped whether the government can make it properly. And I'll come back to that in a minute because it's kind of a very important jurisprudential note. After the decisions in the district court, everyone started freaking out, and it was on to the courts of appeals. The first court of appeals to handle was the Sixth Circuit, which is where I clerked, but I didn't get there until after this was litigated, so I had nothing to do with it. The Sixth Circuit affirmed a district court opinion denying the suit. In other words, Sixth Circuit said this is constitutional. Most famously, Judge Jeff Sutton, who's somewhat seen as a potential Supreme Court nominee in a Republican administration, had this really lengthy opinion that didn't make much sense about some tax issues, but the crux of his opinion is we might not like this legislation, but that does not give us ground to strike it down. It was a very kind of Burkean, restrained opinion, something which you might historically affiliate with judicial conservatives. That we don't move quickly, we don't strike laws down, we're very respectful of the democratic process, and that was really the crux of his opinion. So that was June 29th. August 12th, 2011, this was actually the day before my birthday, I remember it quite well, the 11th Circuit opinion drops. This was a bombshell. The panel in Ohio in the Sixth Circuit had 2 Republicans and 1 Democrat. Law was upheld. This panel had 2 Democrats and 1 Republican, although one of the Democrats was something of a compromise pick. But this was a panel that was expected to rule in favor of the law. But they struck it down. And there was, I think, almost a 300-page opinion with all the dissent. It was very significant. I remember reading this on my first pick because it was the longest actually. And this actually was the first court of appeals that said this law is unconstitutional. This was a very significant thing because now you have a circuit split. Sixth Circuit said one thing, 11th Circuit said another. This has gone right to 1 Street. There's no doubt about it. Then about a month later, so I'd already started clerking and I was already flipping out even more. The 4th Circuit found that the law was constitutional. They upheld the law. So you have a serious circuit split. Shortly thereafter, the D.C. Circuit, also by Judge Brett Kavanaugh, who seems another potential Supreme Court nominee pick, conservative, he said the law is constitutional, the law is upheld. So you have 3 circuits saying that the law is constitutional, you have 1 circuit saying it's unconstitutional, the Supreme Court would go. Then it happens on November 14th, certiorari is granted. That was seen as not much of a surprise. Everyone knew that the Supreme Court would grant cert on this. But what was a surprise was how much time they dedicated to it. They actually dedicated arguments over the course of 3 days for about 5.5 hours. Usually the Supreme Court gives a case about an hour. That's it. This case had 5.5 hours over the course of 3 days, and actually went late on top of that. I think this was the most argument time I've been given in decades. The Supreme Court understood that this case was going to be very significant, and they gave it the amount of time. And a lot of people said, hey, if this case is a joke, why isn't it just a summary reversal? You know, there are lots of dumb constitutional challenges that go up and down, and the Supreme Court just reverses them. I mean, how many of these stupid birther lawsuits do we see? And they're just slapped right down. This is a case where they said, listen, this is legitimate, this is serious, we're going to give it 5.5 hours. That was an entire week of the Supreme Court's docket. And once the cert grant happened, everyone knew that this was going to be a very significant case. The next step was oral argument time. Unfortunately, I couldn't make it to the Supreme Court during that time. I kind of bite myself for not doing it, but in the past I usually camped outside the Supreme Court and slept overnight to try and get a seat. My employer did not allow me to do so at this time. But I did have a lot of friends who were there, and the scene outside the court is just fascinating. The Supreme Court only gives 50 tickets to the public every day, and you can't request them in advance. So it's kind of like camping out for a concert. The only way to get tickets is if you sleep on the sidewalk. People were waiting for 72 hours before the first case on the sidewalk outside the Supreme Court, sleeping outside, because they had a point. I think the first person online I spoke with her, she was a single mother from Atlanta whose daughter had a very serious health condition. She said she needed this law to help protect her daughter. There were a bunch of law students, attorneys, politicians, line waiters. Oh, they're the worst. They charge $20 an hour to wait online. For McDonald v. Chicago in 2009, 2010, I waited outside for about 14 hours in the freezing cold in March. And it was horrible. It just was not a fun experience. I did it again this past term, but it was in June, so it wasn't too bad. And the sprinklers come on. They don't tell you this, around 3 a.m. the sprinklers split. Dead serious. So if you're waiting on nice grass with a nice lawn, the sprinklers come out around 3 a.m. It's a really brutal wake-up call. It's not fun. So you have these people waiting outside, and the worst is the line waiters who sit in multiple spots. So if you think, oh yeah, I'm number like 48 in line, but the line waiter has 4 spots and you get pushed back to 52, you're out of luck. And people pay thousands of dollars to get tickets to this. They pay a lot of money. So we have this significance, this kind of zeitgeist. People realize it's a very important case that there's such a big attention to it. The media was all over the place. Everyone was talking about it nonstop. So there were 4 distinct issues in this case. The first one I won't bore too much involves something called the Anti-Injunction Act. This basically says you can't sue to block a tax until it's actually applied to you. So if the mandate was a tax, then you can't sue until it's actually being applied to you, and it's not going to be applied until 2014. That's fair enough. The first day of argument went pretty well for the challengers. No one really took this argument very seriously. Even the Obama administration didn't take it seriously. They said, we don't think it's a tax for purposes of the Anti-Injunction Act. We want this to be decided now. Now, what was curious, though, was the administration took the position, this is not a tax for purposes of the Anti-Injunction Act, but it is a tax for purposes of Congress's enumerated powers. This will be very important for Roberts' opinion. In other words, we don't think it's a tax for this statute, but we do think it's a tax for purposes of our constitutional power to tax. All right. It doesn't make much sense, but John Roberts thought it did. The second day was the main attraction. This is where all the fun was. And if you listen to the audio, it's absolutely fascinating. This was a day where they decided whether the law would be constitutional or not, whether it was within Congress's enumerated powers. This was the Solicitor General, Paul Verrilli, against Paul Clement and Mike Marvin, who was a representative of the private plaintiffs. The Solicitor General had a very inauspicious start, if you might recall. He got to the podium, he started coughing and clearing his throat. He got some water, you could hear the ice clinking. He was silent for a full 6 seconds before he started. If you actually listen to the audio, it's actually startling. And if you were in the room, it would be even more. This is the most important case of his career, and he's sitting there silent for 6 seconds getting stuff together. It's almost like you call in a student for recitation, like going, you know, they're trying to get their stuff together. This is the Solicitor General of the United States. And he had a very unenviable task. What made his task unenviable is that he didn't have a good answer to their questions. The main question that the justices wanted to answer is, what are the limits on Congress's powers? What limits would you impose? If Congress can do this, what else can they do? And the government steadfastly refused to answer that question. Perhaps for institutional concerns, they don't want to limit themselves to the future. Perhaps jurisprudential things, they didn't have a good reason. But for whatever reason, the Solicitor General did not answer this question, and he just kind of tap danced around it. Paul Clement came up there and he did the performance of a lifetime. He killed it. He knocked it out of the park. He said Congress needs to have limits, and the limit is activity versus inactivity. What does that mean? In the past, Congress has regulated activity, a decision to grow wheat, a decision to grow marijuana, a decision to go into interstate commerce. Here we have inactivity. I don't want to buy health insurance. No activity. You can't regulate my decision to do nothing. And that was the argument advanced. Clement made the argument, killed it. And in fact, Justice Sotomayor actually asked the Solicitor General, how can you tell us that this is a tax for purposes of yesterday, but not a tax, I'm sorry, that's not a tax for purposes of the first day, but a tax for purposes of the second day? And he had no good answer. And Justice Roberts asked the same question. Just keep that in the back of your mind for the future. The next day came severability. Even if this law is unconstitutional, this mandate, can we sever it? Can we cut it away from the rest of the act? This is a big law, and the thinking is, even if we lose this one part, let's at least keep the rest of it. But the government, again, took a position saying it's not severable. They said if you cut out this mandate provision, the entire act will fall. You have these young idiots like me who wait to buy health insurance until they're in the ambulance, and the entire thing will collapse. So the court actually appointed an amici to argue on behalf of this position because no one wanted it. The last day is something of the sleeper issue at the Medicaid expansion. We all know that Congress can't force states to do stuff, but if they tie what's called grants to money, saying, if you do this, we'll give you money, they can do that. This is a very nebulous doctrine from South Dakota v. Dole. It's not clear what the boundaries are. But the question was, the federal government said, if you want your Medicaid money, you have to do a lot of stuff for us with Medicaid. You have to expand coverage. And a lot of states saying, no, we can't afford this. You're coercing us. No one really took this one too seriously. This was kind of like the sleeper issue. And after arguments, it was unclear which way would happen. Now, the next few months were just fascinating. Immediately after the opinion was decided, Jeff Toobin on CNN gets on the TV and says, that was a train wreck for the government. The government's going to lose. All these people are saying the government's going to lose, the government's going to lose. This is just a nightmare. This is horrible. How can they do this? Very famously, and this is actually kind of a Houston relation, President Obama said he was confident that the Supreme Court will not take what will be an unprecedented, extraordinary step of overturning a law that was passed by a strong majority of a democratically elected Congress. So Obama said, the courts can't strike this down. Senator McConnell said that the president was trying to intimidate the judges. A judge who works about 4 blocks that way, Jerry Smith, you might remember this one. He actually had a case involving the Affordable Care Act, and Judge Smith asked the U.S. attorney, or maybe it was a DOJ attorney, does the Attorney General believe in the power of judicial review? Judge Jerry Smith actually asked, in light of the President's comments, does the Department of Justice actually believe that we could strike down a law unconstitutional? And remember that?
Yes.
It was embarrassing. And not only that, he actually asked he actually asked Attorney General Holder to submit a letter to the court signifying that he agrees with the power of judicial review. I know a couple of his clerks, so I won't say too much, but this was a really big deal. And actually, that opinion was decided about 3 weeks ago, in which case Judge Smith voted to uphold the law. And if you actually read the opinion, the word judicial review appears about 7 times, which I think was a little bit gratuitous, but maybe not. So this is like a squabble that's going down between all 3 branches. The president saying the court can't do this. McConnell saying you're trying to intimidate us. You have Jerry Smith saying, do you think we even have the power to do it? Like, go ahead and make my day. It's kind of like a Clint Eastwood moment with all these empty chairs in the room. So it's a very bizarre situation with all these conflicts. And during this entire time that the justices are watching the news. Maybe not Scalia. He says he doesn't read the news, and Thomas says he doesn't read the paper. Fine, but Roberts is reading this. And I have a pet theory that Jerry Smith might have killed this for everyone. Because if you saw the reaction to Jerry Smith's, comment, I'm sure Roberts saw that as well. I'm sure he knew that if I do this, here's what's going to happen. It's at times 1,000,000. So we come to decision day, which was personally tragic for me. The decision came out June 28th. On June 26th, this was supposed to be the last day of the Supreme Court's term. I was there. I had scheduled this months in advance, and I was there. I slept outside the Supreme Court. I came in, and the chief said, sorry, not the last day. What was even worse was, on June 28th, I was on a flight to London. I was giving a talk. And I timed it. The Supreme Court opinions come out at 10 a.m. I gave myself a 9:30 Central Time flight from O'Hare. O'Hare's never on time, ever. I said, okay, if I have a 9:30 flight from O'Hare International, I'll probably leave around 11. These flights never take off on time. And I can get the opinion and read it on the plane. The flight took off 20 minutes early. Because I don't comply with FAA laws, my phone was on until the last second. And I got an update from my friend saying, the mandate was upheld. Roberts voted to hold it up. So Kennedy voted to strike it down. My last text message before I hit the blue skies was, Kennedy would have voted to strike it down, Roberts would have upheld it. I got just enough to sit on a plane ride for 8 hours going, oh my God, let me land already. And then I finally landed, I was so jet lagged I fell asleep. So I finally read on June, I finally read all 200 pages the next morning. I woke up like at 5 a.m. I had no idea what time it was. But I was in this little cramped London hotel room with these little outlets going on. But I got the opinion. I don't know how much I paid for it, but I got it. And I read it, and I was like, oh my God, this is insane. This is insane. Let me try to explain what actually happened in the opinion. It's not clear. So, the law was upheld. That much is clear. The 4 dissenters, that is, Scalia, Thomas, Kennedy, and Alito, they would have struck down the entire thing because there was a violation of Congress's enumerated powers. That's fine. Ginsburg, Breyer, Sotomayor, and Kagan, they said that this law is constitutional under Congress's powers. They also said it's a valid tax. Roberts took kind of the bizarre position that this law violates the Congress's enumerated power, but I will save it. I will save it by construing it as a tax. So you had a 5-vote coalition saying this is a valid tax, We also had a 5-vote coalition saying this violates the Commerce Clause. If you're wincing, so am I. It's a bizarre position, and if you look at Roberts' opinion, if he wanted to say that the law was a valid pact, he didn't need to spend 40 pages and waste all my time reading it, saying why this would violate the Constitution law. That's called dicta. You don't spend 40 pages deciding something that doesn't matter to your opinion. So going forward, it's going to be very much unclear what's going to happen. In fact, there was a lawsuit filed 2 days ago saying that because this is a tax, it violates the origination clause. Taxes must originate in the House. This law originated in the Senate. So by Roberts' own word, this is actually a tax that originated in the wrong House and it's unconstitutional. It's going to be a mess. I have no idea where that suit's going to go, but if Roberts is right, then I guess it's so. The other aspect of the case was interesting was you had 7 votes to strike down the Medicaid expansion, or at least parts of it. You actually had the 5 conservatives, and then Kagan and Sotomayor, Kagan and Breyer joined on with the conservatives to strike down part of the Medicaid expansion. When this came out, everyone was going crazy. No one knew what was up. Shortly thereafter, there was actually a rumor that leaked by Jan Crawford. I was actually in London when I saw it, that said that Chief Justice Roberts might have switched his vote. There's some anecdotal evidence in the opinion that that's the case. I don't know if it's true or not. In fact, I don't know if it's that uncommon for justices to switch their vote. It happens. You know, very famously in Planned Parenthood v. Casey, O'Connor, Kennedy, and Souter kind of formed together a troika, and they kind of all swapped off their votes, so hold the law. So it's not unprecedented. So that's the opinion. That's the legal story. But the important part is what happened outside of the court. There was so much activity going on outside of the court that is fascinating. And I'll take you a point that you alluded to in my introduction. Let's go back to November 2009. Totally, auspiciously, I was at the Federal Society Lawyers Convention, where I usually am in November. And there's a prominent lawyer, Todd Graziano from Heritage, and he was effectively walking around the halls like he often does, saying, hey, this law is going to be passed in a couple months. We got to do something about it. We got to challenge its constitutionality. And then he came up to me and said, hey, Josh, you're a prominent blogger, you're in this legal whatever. You want to write something looking bad? I was like, well, I know what to write about. I mean, under Wickard and Raich, this is interstate commerce. This is, this is fine. And he asked me, well, could Congress make you buy a GM vehicle? This was right on the ballot times. And I was saying, well, why? I mean, there might be some individual liberty interest, but there's nothing wrong with the enumerated powers here. And he was just walking around. And then who comes by but, Randy Barnett. And Randy Barnett is the godfather of this movement. We'll know him as the expert. And I will give you an exact quote. He says, Todd, I haven't given this much thought. I'll think about it. At the time, no one had thought about it, not even Randy. And Todd said, hey, Randy, listen, come by my office on Monday. I got an associate. We'll help put together a report. We'll write something together. We'll figure something out, and we'll publish it. And he's like, okay. They actually asked me to contribute to that report, but I couldn't because I was clerking, and that would have been probably not a smart move to comment on pending litigation, so I didn't do that. So a couple weeks later, the Heritage Foundation puts out this white paper. This white paper made the argument that in the past, Congress can regulate activity, but they can't regulate inactivity. This was the first time this really argument, this refined stage had been advanced. And it was a brilliant argument that worked so well. What made this potent, though, wasn't just that some law professors were making arguments. We've all made arguments before that have been totally ignored, and that's usually what we do. What made this potent was that the political process got behind it. At that event, Senator Orrin Hatch was present. He was there when this event kicked off, and he put the imprimatur of the Republican Party behind this. So you had this kind of bond between, legal academics, and you have the Republican Party getting behind it. That was the first key step. The second key step was the Tea Party. This was a movement that emerged nebulously at some point in 2009 as a reaction to mostly Obama's election, but also growth of government, high taxation, dilution of the gold standard, all these other gripes. But the Tea Party was able to rally around this cause. Why? Because it hit a lot of the key notes. First, it focused on limited government, restoring power to the states. Second, it kind of focused on, what does the Constitution mean? What are our constitutional founding values? And it had a lot of resonance with the Tea Party. So you had this kind of, this trinity between legal academics working with the Republican establishment through the Tea Party to advance this social movement. And by pushing this movement through, you had a lot of stuff going on outside the court that allowed the stuff inside the court to happen. The opinions in Florida and Virginia would never have happened if this movement hadn't happened outside of it. This is what gave them groundswell. The enduring image of the Tea Party became a piece of broccoli, which actually might be the cover of my book. I'm still debating it. It goes both ways. Can the government make me eat broccoli? If I eat broccoli, it'll be more healthy. Can they make me eat broccoli? This was the issue. In Fred Vinson's opinion, he actually said, can the government force you to buy broccoli? At the United States Supreme Court, Justice Scalia asked, can the government force you to buy broccoli? These images, these themes, these constitutional norms were transplanted from outside the court into it. This wasn't some kind of long-standing development of constitutional jurisprudence that we often see. Take District of Columbia v. Heller, for example. That was a 20-year battle over original sources of what the Second Amendment meant. This was a very long, protracted battle. This happened in 2 years flat. This happened fast. The only reason it happened as fast is because you had the constitutional backings behind it. And when you have people like Nancy Pelosi saying, are you kidding me, is it a joke? And you have, top scholars saying that this holds no water, this has no merit, then you actually have judges trying to strike it down. It's quite unprecedented. And what helped change this is really this constitutional movement, this popular constitutionalism between, the academic idea of how the Constitution should be received. You have Senate Republicans kind of getting behind it. You have the Tea Party rallying around the cause of the Constitution, and they create something of a perfect storm to allow this challenge to happen in such a short, condensed time. Now, what's interesting about the litigation strategy is it wasn't your regular conservative litigation strategy. It wasn't originalist. Not at all. In fact, the challengers conceded this is not based on the original meaning of the Constitution. This is based on precedent. But it wasn't just based on precedent. Throughout the entire challenge, if you actually look at what the challengers said, they think, this law is unpopular. People don't like it. This is going to violate some sense of liberty. There was the argument, and then there was the subtext. The argument was, Congress has never done this before. But the subtext is, this is going to be really unpopular, court. So if you want to look to what people are doing, kind of will the people, don't uphold this law. And this is something novel for conservatives. Conservatives have been usually restrained, being a judicial restraint, being Burkean, John R. Eatley. Be a restrained judge. But this is the opposite, saying, listen, look to the people. This is not popular, strike it down. But the strategy has a serious potential backfire. And I think that's might have what happened. When you start telling courts to ground your opinion in what people want to do, you don't know which way that comes out. John Roberts could have made a calculation that, well, this might be actually worse if I uphold it, so by looking to the will of the people, I'll make sure this law is constitutional. I'll do this bizarre opinion, or I give the conservative something, but I uphold the law. The very strategy that was meant to kill the Affordable Care Act might have actually saved it. And that's really the thrust of my paper. And it's going to be developing and presenting it several times over the next few months. And I welcome any questions. Matt?
Are you explicitly adopting or using Larry Kramer or Bruce Ackerman type popular constitutionalism to explain what's going on? And if you are, is it part of your thesis or something you consider that I don't know of any other, if you're right, I don't know of any other instance where popular constitutionalism was used to ratchet Congress's power back rather than to expand.
Exactly. And that's why this case is unprecedented. And I like the way you phrase about ratcheting power forward or back. Usually this is a very liberal strategy by progressives. You look at the Warren Court in the 1960s, this is a way to expand government power. This is really, in my mind, one of the first times that conservatives have challenged a law in this manner. This wasn't based on what James Madison thought, like the Commerce Clause, or what, or striking down some expansive welfare state. This was based on a conservative libertarian idea of what the Constitution should mean, grounded in terms of look to what the people think should happen. And it's really, it's really fascinating if you kind of look at the entire history. And that's why I laid it out the way I did. By just looking at the opinion on what happened in June 2012, you missed the entire bigger story.
Yeah, the thing that I find most interesting about the whole thing is that the conservatives didn't make the argument in court that actually is the one that resonated with the people, which is it's a denial of liberty, it's a denial of freedom, which is a due process argument.
Yes.
And they specifically did not make that argument. They didn't take that to the Supreme Court. And I'm just wondering in the whole context of it, I mean, to me, if you're a conservative, you would think the government can't force me to buy broccoli. That would apply to the federal government or state governments or city governments. And yet that wasn't any part of the legal argument. To me, they gave up really the popular constitutionalism argument and sort of had to then make it only on basis of federal power. And the taxing thing, to me, is perfectly sensible. I don't know why, to me, you say it's not sensible. To me, it's perfectly sensible. It operates like a tax. Congress has broad power to tax. It's a tax. I mean, to me, what Robert said is sensible on that. But I just wonder why, in any of the discussions that you had with Federalist people, why they didn't make officially the due process.
They didn't want to lose. They knew that, and I agree with you, and I'm something a libertarian myself, I like the liberty argument. I think that resonates very well. They knew if they made that argument, they'd be accused of being Lochner and they'd be shot down very quickly. They knew that if they grounded this in terms of individual liberty, they'd lose. But one other point that's related, had they grounded it in some sort of liberty challenge, Senate Republicans would not have gotten behind it the same way. They like doing stuff to people. They like infringing individual liberty. They like making people do stuff or telling people they can't do stuff. The way that this argument was ingenious was it fits in perfectly with just this case. This strategy could not be imported to any other case. Unless Congress imposes a mandate on activity or inactivity, this strategy is a one-off. It's kind of like a one-time deal. So, Randy, you're absolutely right. They didn't want to do that because they knew they'd lose. I like that.
I guess I'm not sure. I mean, I guess you're telling me that was their thinking, so that explains it. To me, I'm not sure if you had sort of vigorously made that argument, which is your real argument. It's the one that resonates with people. With Tea Party, you're violating my liberty, my freedom. How can they force me to do something? I guess I'm not so confident that you necessarily would have lost that one.
But they did lose. A lot of the, for example, the Thomas More Center, which is a religious right group, raised a number of points saying this violates my freedom of conscience, this violates my due process rights. And those opinions were dismissed out of hand. They didn't get any traction. There were a number of suits filed by religious organizations, and they didn't go anywhere. The only challenges that went anywhere were those backed by these kind of movements, which is activity versus inactivity. That's the only argument that went forward. But I personally agree with you. I wish they would have made that argument, but I guess they're smarter than me, and they realized they would have lost.
Well, maybe, though they lost. I don't know if they're smarter than you.
Well, I don't